I'm Jan Paynter, and I'd like to welcome you again to our program, Politics Matters. Our guest today is Professor G. Edward White, who has kindly agreed to return with us to continue our discussion about the Supreme Court. Professor White is David and Mary Harrison Distinguished Professor of Law at the University of Virginia. Professor White holds a BA from Amherst College, a PhD and MA from Yale University, and a JD from Harvard Law School. Dr. White became a member of the UVA faculty in 1972, having clerked for Chief Justice Warren of the Supreme Court. He was twice a senior fellow of the National Endowment for the Humanities, a Guggenheim Fellow, a fellow at the Society of American Historians, and a member of the American Law Institute. Professor White is the author of 14 books and numerous articles on law and legal history. He has won an impressive number of awards and honors, including a final listing for a Pulitzer Prize in History. His many books include History and the Constitution, Collected Essays, The Constitution and the New Deal, and the Marshall Court and Cultural Change, 1815 to 1835. Welcome again, Professor White.
Thanks.
Professor, last time we were discussing the original structuring of the Supreme Court as referenced by Article 3 of the Constitutions. We were talking about the duties and responsibilities of the original justices, and most particularly the appointment by John Adams of John Marshall to be our fourth Supreme Court justice. And this in turn leading to the landmark case Marbury versus Madison in 1803, which first allowed the court to overturn a law passed by Congress if it was deemed to violate the Constitution. Thus, we introduced the role of the High Court into judicial review for the first time in our history. We talked about the subsequent back and forth, the contentious arguments which took place between Jefferson and Adams over the relative importance of the Federalist versus the Republican point of view. Define for us again, if you would, Professor, the distinction between federalism and republicanism as it was understood in the late 18th, early 19th century.
Well, the distinction starts with Washington's administration. In the last phases of Washington's administration, Alexander Hamilton and Jefferson emerge as spokespersons for different theories of the relationship of the federal government to the states. Hamilton basically taking the position that there should be a strong, aggressive federal government with a fair amount of control over state affairs. Jefferson taking the position that state autonomy was more important. And these political divisions eventually surface in the form of different political parties, so that by the time that John Adams becomes president, and for the duration of Adams' presidency, Jefferson is in effect a leader of the opposition. And then in the 1800 election, Jefferson challenges Adams. And he actually describes a political party that he heads as the Republicans. Adams is running as a Federalist. It's a close election. It's thrown into the House of Representatives, and Jefferson wins. That means for the first time in American history that we actually have a partisan change in American politics. So the Adams administration leaves town, Jefferson administration takes over, and before Adams does, he makes a number of appointments to the federal judiciary, including John Marshall to the Supreme Court. So when Jefferson begins his administration, the division between Federalists and Republicans is in place.
Okay. As we saw last time with the Federalists prevailing over Jefferson, we were discussing this sort of pamphleteering and the back and forth issues and the controversy that ensued. Tell us a little bit about the ways in which information was disseminated to the public at that time.
Well, one has to remember in this period that although there are newspapers, and although newspapers circulate, the modes of communication are limited. It takes a long time to get from one section of a country to another. And so another way in which Americans, and of course there's also no other sources of information. I mean, we don't have television, we don't have radio. So another way in which Americans get information is through local pamphleteering. And what emerges in the period against the backdrop of partisan conflict are anonymous, basically printers, people who own printing presses, who then become, we would think of them as the equivalent of bloggers today. They're issuing pamphlets on a variety of issues. And they usually don't sign them by their names. They usually sign them, they usually make allusions to classical. They'll call him Tacitus or some figure from the classical period. And this pamphleteering is going on for almost the entire time in which when the Marshall Court is organized. That is between 1801, when Marshall starts, and 1835, when he retires. There is constant pamphleteering, critical of the court, critical of the administration that goes on.
Now, when you were mentioning the references to Tacitus, would this presume that the people looking at the pamphlets were, learned? Was that a privileged number of people, therefore, that were reading them?
Yes, of course. Many people in the country can't read at all.
Right.
The educational system is fairly limited. So these messages are circulated to elites, but then they're disseminated from elites to others. So that people will read the pamphlets and talk about the issues, and that's how other people in the population will become aware of them.
One of the things that I thought was very interesting in reading your book, you talked about the fact that at this time there were no written briefs. Decisions that were made by the court were oral, and therefore people didn't necessarily hear a great deal about the decisions of the court.
Well, first, as to the briefs, the court did not have a requirement that lawyers who argued before it submit written briefs. They would often submit a one-page summary of their argument, but even that wasn't required. So one of the differences between the modern court and the Marshall Court is that the justices are taking notes while the lawyers argue. And part of the reason they're taking notes is because the lawyers are presenting them with sources for their opinions, which they're not getting in any other fashion. Now, as to the dissemination of the court's opinions, there is a reporter for the court. Originally, this is a private entrepreneur who just decides that he will report and publish the court's opinions and try to make some money off it. Beginning in 1815, the court gets an appropriation for a salaried reporter, and from then on, the reporter is paid. The reporter is charged with taking opinions that are in draft from the justices, handwritten, and editing them, providing additional support, footnotes, and so on, and then publishing them in reports that bear his name. So Henry Wheaton is the reporter for some of the Marshall period. The reports come out as Wheaton's reports. They don't come out contemporaneous with the actual release of the opinion. The court meets in a limited period from January to March, and they hand down opinions. Sometimes the text of those opinions will appear in newspapers. Mm-hmm. But more commonly, the text will not be reported, and it will not come out until many months later when the U.S. opinions are published. And the people who read those opinions are a very limited number of people.
I see. It's fascinating that a reporter would be involved in this process. I can't imagine that today. You mentioned another thing after we filmed yesterday, last time, about the fact that the justices really had very little weight of precedent before them, that they were freer than almost any other period after that to make law. There are obviously advantages and disadvantages to this from the point of view of a justice, the justices on the court. Do you feel today, for instance, that our justices are somewhat overly constrained by the weight of precedent? What's your feeling about that?
There are just many more published decisions of the court. In the Marshall Court period, first of all, you don't have a long history of court decisions, but you also don't have a lot of published decisions. So many cases the Marshall Court decides are raising issues for the first time. Of course, the modern court has a long history of precedent.
Exactly so.
The current court is self-conscious about precedent. Indeed, it's now become fairly common in cases where the court is overruling a previous decision. Citizens United is an example, the case involving campaign finance, corporations' ability to have unlimited expenditures. The court's justices take some time in that case to say why they're overruling a precedent and how much weight they give to precedent. Marshall Court justices don't do this at all.
Interesting. So the Marshall Court, we know, resulted in a somewhat larger footprint with respect to the powers of the court. The federal government is the guardian of the law. The subsequent court, the Taney Court, how did Justice Taney react to the Marshall Court? Did he share Marshall's views? Did he diverge?
Well, first of all, he certainly doesn't share Marshall's views on the major issues, constitutional issues of the period. I mean, Marshall is an advocate of federal power. Taney is a strong advocate of state power. The Taney Court, from almost the beginning, is affected by the relationship between slavery and westward expansion. This is the period, Taney's on the court from the 1830s to the 1860s. He's still on the court when the Civil War breaks out. His appointment was in 1837. That period is a period in which there's considerable westward population movement, and which it's discovered that slavery has the potential to flourish in the Trans-Appalachian and Trans-Mississippi West, or at least in some sections. So the issue of how much power the federal government or the states will have with respect to slavery. Remember, there are lots of federal territories in this period. The United States has purchased a lot of land. A lot of the area is held as a federal territory before states are created out of it and enter the Union. The federal government takes the position it can outlaw slavery in the federal territories. It's also understood that states control whether they want to have slavery or not once they become states of the Union. So there are a number of issues swirling around this. There's also the problem of fugitive slaves, and the Taney Court gets involved in all these issues. And so an issue that the Marshall Court's generation managed to avoid, that is, the future of slavery, it is central for the Taney Court.
Yes, I'm guessing the Marshall Court did not get too much involved in civil rights issues, and I know the Taney Court, at least from what I read, Justice Taney believed that, for instance, the infamous Dred Scott decision that's familiar to most of us, that this would help avert civil war to some degree, and in fact it seemed to do precisely the opposite, and shut down debate on the power of Congress to ban slavery. So what kinds of decisions subsequent to Dred Scott with respect to civil rights came up which were momentous?
Well, the Taney Court assumed that if they could craft a definitive solution to the constitutional issues affecting slavery, that would, as you say, that would sort of stop the agitation. Dred Scott had just the opposite effect. The Republican Party in 1860 campaigned against Dred Scott and took the position that it was going to be opposed to any slavery in any further federal territories. The result eventually was civil war. Certain southern states that had a deep investment in slavery felt threatened, believed that the future political history of the country was going to be going against them because the population centers were in the north. As more states came into the Union, the balance between slave and free states was going to be disrupted. They thought the next effort would be eventually to put pressure on the South to abolish slavery. So we have the Civil War, and then, of course, in the aftermath of the Civil War, we have a Republican-dominated Congress that institutes Reconstruction. And it's at that point when we have the 13th, 14th, and 15th Amendments, and we have a new set of, using your language, a new set of constitutional liberties and rights. And then that sets the stage for a reorientation of American constitutional jurisprudence with a much greater emphasis on civil rights and liberty.
I was fascinated to read that in 1875, Congress actually passed a Civil Rights Act forbidding racial discrimination in public accommodations, but the Supreme Court struck it down on the basis the power had no power to regulate private discrimination. That was rather startlingly early. And then obviously we kind of went back and forth in terms of this issue. We later have Plessy versus Ferguson and the famously the separate but equal ruling. Talk more about, if you would, Professor, about the role of the 14th Amendment in shaping the High Court's decision at this time.
Well, remember, the 14th Amendment is a product of a Congress that is deeply opposed to the South and anxious to impose a more egalitarian and libertarian regime in the South, is supportive of racial minorities to a limited extent. But then what happens is, after the period, about 10 years, just about the time of the passage of the Civil Rights Act, which is still very much influenced by the Reconstruction Congress, there's kind of an effort to get past the Civil War, to welcome Southern states back into the Union, and the understanding is that the reintegration of the South is going to be done at the expense of liberties for African Americans. So the construction of the 14th Amendment not to apply, and the Civil Rights Act not to apply to private discrimination, is part of that sort of tacit understanding. And this goes on well into the 20th century. It goes on in the 1920s. We still have enforced segregation as the dominant policy on all branches of the government in the 1930s.
How did the so-called doctrine of incorporation and applying the Bill of Rights to the states affect justices and decisions on the court?
Well, it's a very important move, because the original text of the Constitution does not anticipate that the states are restricted by things such as due process rights. It is necessary to have the 14th Amendment with its own due process clause, with its equal protection clause. And then the next question for justices is, does this mean that due process, as opposed as enforced against the states, includes the original Bill of Rights guarantees? And eventually the court concludes that it includes some of them. Well, that's very important, because most of the restrictions of civil liberties take place at the state level rather than the federal level.
Looking at the, moving ahead in time to the New Deal period in Roosevelt's court, I found this kind of interesting. Who are the four horsemen and the three musketeers on the court? Obviously, at this time, you have much more, it seems, a structure of polarization, conservative versus so-called liberal, and swing votes that then prevails as the courts go forward, and seems to be the basic makeup of the courts. Would you say that during the Roosevelt period, this solidified a bit more? And so tell us about that, if you would.
No, the designation of justices as liberals and conservatives comes very late, really, in the commentary on the court. Justices are not designated in that fashion until the 1930s.
Okay.
And the designations come in the popular media.
Right.
And they center around a controversy that emerges on the Hughes court how receptive are the justices going to be to New Deal legislation which enhances the power of the federal government, and also to social welfare legislation at the state level. And so you get what is called, the terms the Four Horsemen and the Three Musketeers are journalistic terms to signify the attitude of some justices on the Hughes Court toward these issues. The Four Horsemen of the apocalypse, that is to say, that portrayed as reactionaries who are resisting constitutional change. Justices Sutherland, Vandeventer, McReynolds, and Butler. And then you have three justices that are portrayed as sympathetic to the New Deal and to constitutional change: Brandeis, Stone, and Cardozo. And then you have two other justices, Hughes and Roberts, who are given the label swing justices. Now, these labels are vast oversimplifications. They neither capture the individual justice's attitude, nor are they limited to a very small sample of cases. But they become kind of popular epithets. And from then on, the court justices are described and continue to be described. The Roberts Court justices are described as, quote, conservatives or liberals, even though those labels are vast oversimplifications.
So this was really, in some ways, as you said, in the 30s, with the Roosevelt's court period, the beginning of kind of hype and press labeling. So, but not at all according to the reality of how the justices made decisions.
It's a beginning of an image of justices as political figures. It's not that they were never thought of as partisan. They were. I mean, the commentary in the Marshall Court suggests that people think the court is partisan. But the idea that justices are sort of no different in a way from congressmen in their attitudes, and that you can take constitutional cases and describe them in political terms is a 20th century phenomenon.
When I was reading Jeffrey Rosen's book, it was a rather useful book on the Supreme Court, one of the things they mention in an overview is that in general terms, and obviously this is very general, from the Civil War to the New Deal era, we move more, as we talked about before the program, from a concern with property rights, admiralty law, to civil rights. Do you think this is a fair characterization of the gradual shift of the court preoccupations and cases?
Yes. I think that what he's describing is a change from what I would call Republican to Democratic constitutional theory. In Republican constitutional theory, the judiciary is a guardian of individual rights against the state. And most of those rights are defined in terms of property rights. So the critical cases for that period are where states try to use the police power to restrict property rights. The move to democratic constitutionalism suggests that majoritarian rule is important, and the relationship between the United States as a democracy and freedom of expression, for example, is a critical way to define the United States from Hitler's Germany and fascist Italy and communist Russia. So free speech particularly becomes a central concern for the court in the 1930s and 40s. Property becomes less of a concern because that court is more supportive of legislation that restricts some property rights.
Well, it's interesting that you bring up free speech. There's a recent case which I believe the Supreme Court is going to take involving a Topeka, Kansas situation with the father of a Marine who was killed in Iraq. And he is in a pitched battle, really, with a church out there because they tend to picket during funerals. This has been much in the news lately. And his argument, of course, is privacy issues, and the church's issue is free speech. And I'd be interesting to see, I know this started in October, when the court takes it and how they decide.
Well, this actually, I don't think this case, although it's an unfortunate case, but I don't think this case is as difficult as it may be portrayed. It is clear that you can hold a rally and express your views on a public street. If that happens to be adjacent to where a funeral is taking place, that may be unfortunate, but you can do it. There is a doctrine in free speech jurisprudence called public forum doctrine. That means essentially that there are designated areas where citizens can express their views, and they tend to be public areas, streets and parks, for example. And although the government can sometimes regulate these areas, for example, they can ask for a permit to speak in a park, or they can say you can only speak in certain hours of the day. Other than that, there's not much control, and they particularly cannot regulate the content of what is being said. So if these protesters stood outside the area where there was a funeral taking place and chanted, even if the chantings were highly offensive to the family holding the funeral, or maybe even disruptive of the funeral, that speech is probably protected. Now, if it tends to aggravate a breach of the peace or something, that's another matter. But if you just basically express your views, even though they may not be attractive ones, in a public forum, then they're typically can't be regulated.
So likely then that the justices, if they take the case, would rule in favor of free speech and the church.
Yeah, unless there may be some facts in the case that suggest that the protesters actually invaded the private property on which the funeral was taking place. That would be a different matter.
But failing that,
even though these are offensive comments and clearly were directed at the family involved because it was the funeral of a person who had served in the military, so even though it's clear that they would cause some distress, absent the ability to show that this sort of intentional infliction of emotional distress, I think the speech is probably protected.
I want to thank you for agreeing to be with us again today. I want to thank you at home for joining in on our discussion. We have posted a number of books on our website which relates to present and past programs at Politics Matters, as well as interesting websites, columnists, and blogs on both sides of the aisle for you to look at. Our website address is politicsmatters.org. We'd like to hear from you with all questions and concerns for upcoming programs on Politics Matters. You can email us at info@politicsmatters.org. Thank you until next time, and thank you again, Professor White. I'm Jan Paynter, and Politics Matters.